Hello everyone, this is Cassidy O'Connell with big news today in the Alex Murdaugh saga that never seems to end. I've been working on an episode about the Fox Nation documentary, The Fall of the House of Murdaugh, that I was hoping to get out today, but this has interrupted that. Dick and Jim just announced a motion for a retrial based on, of all things, jury tampering by a clerk of the court, Becky Hill. It seems she entered the jury room before Alex was about to testify and told the jurors not to be fooled by Alex, to watch his body language. He's lying about everything, among other things. We'll get to all of it in the 65-page motion that I'm about to read to you. She's been on a book tour promoting her book, Behind the Doors of Justice, The Murdaugh Murders. As you see here, there will be excerpts from this book also in this document. But I am so mad. This is just unbelievable. A clerk of the court could be the unraveling of this whole trial that so many people worked so hard on that cost the county so much time and money. I hope she enjoyed her little book tour because she's about to become the most hated woman in America. It's a long read, as I said, 65 pages, so go grab snacks and a drink and let's get started. It was filed September 5th in the Court of Appeals in Colleton County. It's a motion to suspend appeal and for leave to file motion for new trial. It says, Appellant Richard Alexander Murdaugh, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves for leave to file a motion for a new trial based on after-discovered evidence in the Court of General Sessions, and to suspend this appeal during the pendency of the motion. Appellant offers a copy of the motion for a new trial attached as Exhibit 1. With its own exhibits labeled Exhibit A through Exhibit L, as the memorandum in support of this motion and documents supporting facts relied upon not contained in the record on appeal, as required by the Rule 240 of the South Carolina Rules of Appellate Procedure. Respectfully submitted, Richard A. Harpootlian. Now, it's important to remember as I read these that these are all allegations at this point. Nothing in here has been proven. She has not been found guilty of this in a court of law. So every word of this document is an allegation. So, Alex moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Specifically, during trial, the Colleton County Clerk of Court, Rebecca Hill, she told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. Statement of Facts gives a quick outline of the trial that Alex was indicted on July 14, 2022, his murder trial beginning January 23, 2023, presiding judge, Judge Newman. It ran for 6 weeks and ended with a conviction on March 2, 2023, and sentencing the next day, March 3rd. Defense began its case on Friday, February 17, 2023. Court was not held on February 20, which was President's Day. After returning from the holiday, Ms. Hill began to enter the jury rooms often. And this is according to Exhibit A. When it lists an exhibit, I'm going to go ahead and go straight to that exhibit. Of course, the names of these jurors are all protected. This is just simply listed as juror number 630. And it states, personally appeared before me, juror number 630, who being first duly sworn, deposes and states as follows. I was juror number 630 in the case of State of South Carolina versus Richard Alexander Murdaugh, tried in Colleton County, South Carolina. Toward the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including look at his actions and look at his movements, which I understood to mean that he was guilty. Immediately after he testified, the foreperson, juror number 826, said Mr. Murdaugh was crying on cue. The foreperson, juror number 826, criticized the former foreperson, juror 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury we cannot interact with Mr. Murdaugh because that is what the defense wants us to do. The jury frequently discussed the case during breaks before deliberations. Toward the end of the trial, Miss Hill came into the jury room a lot. Miss Hill and the foreperson juror number 826 had private conversations on multiple occasions. The foreperson juror 826 would tell the bailiff that she needed to speak with Miss Hill. Miss Hill would arrive, and then she and the foreperson, juror 826, would go to another room to have a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson, juror 826, never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently toward the end of the trial. When we began deliberations, Miss Hill told us that this shouldn't take us long, and that if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but were told they could not smoke until deliberations were complete. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by other jurors. After the verdict and immediately before sentencing, Miss Hill pressured the jury to speak as a group to reporters from the television show, and that's redacted. For the sake of time, this episode is going to be more podcast style where I don't add slides for each part I'm talking about, just so I can get it out tonight. In the future, I will add slides and repost it if you prefer to read along. Thanks for understanding. Back to the main document. As the defense began its case, Miss Hill told jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." And that's according to Exhibit B. Exhibit B is an affidavit of Holly Miller, who is a paralegal for the Harpootlian law firm. It states, "Personally appeared before me Holly Miller, who being first duly sworn deposes and states as follows. On August 6, 2023, Dick, Jim, and I met with Juror 741 in the case of State of South Carolina versus Alex at her home, redacted. At the meeting on August 6th, Juror 741 indicated she would sign an affidavit. However, we were unable to arrange with her a suitable time and place. During the meeting, Juror 741 relayed the following information to us. During the trial, she witnessed the clerk of court, Becky Hill, come to the jury room, and Miss Hill and the foreperson, number 826, went into the bathroom. After Miss Hill and the foreperson exited the bathroom, Miss Hill told the jurors that they couldn't ask the foreperson questions. Several times during the trial, Miss Hill told the jurors that the media would want to interview jurors at the end of the trial, and during one of these conversations, she passed out business cards from the media to jurors. At the end of the trial, Miss Hill told Juror 741 that no one from the media wanted to interview her. Right before the defense put up their case, Miss Hill told the jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." After Alex testified, 8 jurors indicated that they did not believe his testimony. Redacted name recalled, Juror 544 was very emotional during the trial. During the visit to Moselle, Juror 826 and redacted walked to the scene together. Then Juror 826 began walking with the clerk of court, Becky Hill. There were times the jurors were not kept together but were in 2 separate rooms. Redacted name, noticed jurors talking about the case before deliberations began. Neither she nor juror 785 joined in on the conversations about Alex. As the jury was deliberating, she believes Judge Newman came to the room she was in and told her the jury would have to spend the night at a hotel if they did not have a vote by a certain time, but she does not recall the time deadline. Juror number 741 was the first former juror to provide information that the clerk of court made statements to members of the jury about the evidence presented during the trial prior to jury deliberations. Ms. Hill's conduct was corroborated by other jurors during subsequent interviews. So a lot of the actual document is just kind of paraphrasing things that we're going to read in the actual exhibits. So I will skip a lot of that. Moving on to page 3. The next court date after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th, the day Mr. Murdaugh's testimony concluded, while perusing a Facebook group page called Walterboro Word of Mouth, and that will be Exhibit C. The post, purportedly by juror number 785's ex-husband, Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. Exhibit C is a draft transcript of records excerpt from an in-camera conference on March 1st, 2023 about this topic. I'm going to start with line 3, the court. Okay, well, let me see what Becky's talking about. I wanted to revisit the Facebook post that you mentioned yesterday. Miss Hill. Right. The court. That's Becky Hill, the clerk of court. Can you tell us about that Facebook post? Miss Hill. Yes, I think it was Friday evening. Just for a brief moment, I perused Facebook, got on Walterboro Word of Mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he noticed his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I just kept on scrolling, because that was enough for me. I've gotten enough. The court. And how did you determine who he was talking about? Miss Hill. When I heard there was an email on Monday, I figured the two went together, if it was true. The court. Well, she's confirmed she has an ex-husband who she has 3 restraining orders out against, so... Miss Hill. Right. So then we looked on Monday after you told me to try to go back and look for it. And we couldn't find it. But then we found out his name, and we found the post and printed it out where he said that he had put something up, but that he had deleted it at the time that he had put stuff out that wasn't nice. The court. He said he got drunk afterwards. Mr. Meters. Something about the devil? Mr. Harpootlian. Didn't he say it was Satan in it? Miss Hill. Satan was in it, yes. In all the details, yes. The court. All right. Miss Hill. Made me do it. The court. Okay, I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got this information from. Miss Hill. I don't. I can find it, though. Mr. Fernandez. We do know his name for what it's worth. The court. Do you think he will be sober? Miss Hill. I don't know. Probably not, if I had to guess. Mr. Harpootlian. It is Wednesday. Well, is today Tuesday or Wednesday? Mr. Fernandez. Wednesday. Mr. Harpootlian. Well, it's Wednesday night, so he's... And then it ends. Exhibit D is an excerpt from her book. I'm not going to read all the pages that they included in here, but I'm going to start with the beginning of Chapter 12, We the People, Duty, Honor, and Service. She quotes a scripture that I'm not going to read. Working with jurors is always a unique experience, and like with any jury, we had some behind-the-scenes happening with our jurors, the alternates, and the originals for the Murdaugh trial. While most of the jurors were focused and engaged during the murder trial, we did have one juror who was an alternate at one point, who was not. She was more focused on the crowd, who was watching, who was or wasn't following Judge Newman's rules, and so on. For example, she caught a new visitor to the courtroom who was sitting directly across from her, who looked like she may have been taking a picture of the jury, and that wasn't going to fly with her. Another juror couldn't or wouldn't sit still during the trial, and it seemed like every time she shifted her chair, it made a loud squeak. Occasionally, attorneys would wait for the rhythm of the squeaks to subside before continuing their cross-examination. Then, there was the egg lady juror. This juror worked on a monkey farm in the Low Country, and she drove Judge Newman bananas one weekend. Pun intended. Through the Facebook page Walterboro Word of Mouth, about 20,000 followers saw this juror's ex-husband post about how she was talking way too much to friends and family about the case. Many people became aware of the situation after court on Friday, February 24th, and it was brought to the attention of Judge Newman. I typically didn't have the time or energy to watch any media coverage of the trial, but on that Friday night, I scrolled through the Walterboro Word of Mouth social media feed and saw the post from the ex-husband, but he didn't mention the juror's name or her juror number. At the time, I didn't think anything of it and kept scrolling, mainly because I had been inundated with emails and messages from people all over the world about what they had heard, what they had seen, how the prosecution and defense should run their cases, how Judge Newman should rule, what to address with anyone and everyone involved in the courthouse, and so on. I felt like a principal dealing with tattletales and problems and issues every day. It was tiring. Apparently, she loved it. When Monday morning came, Judge Newman asked me to find the social media post. One of our techies in the clerk's office, Lori Weiss, looked and couldn't find it at first. Luckily, though, she kept looking and saw where the post was taken down and replaced with an apology from the juror's ex-husband. He said Satan had got a hold of him, and he'd been drinking at the time he posted and was now very sorry. After Judge Newman interviewed the juror and corroborating witnesses about the situation, he removed the juror from the jury before court started that Monday morning. We learned later that the ex-spouses hadn't seen each other in 14 years, and the former juror had 3 restraining orders against her ex-husband. When a juror is removed from a jury, it's normal practice for the judge to ask if there are any personal items they'd like to retrieve from the private jury room. When Judge Newman graciously presented this question to the former juror, she said she just wanted to get her eggs, which caused some laughter in the courtroom and nationally once the media got a hold of the story. Judge Newman even broke out into one of the largest grins I've ever seen. One of the other jurors raised chickens on their farm and had brought in a dozen eggs to whomever wanted them. At this time, eggs were selling for about $8 a dozen, which was very high, so it's understandable why the removed juror wanted her eggs. One of our local singer-songwriters, then it skips 11 pages. While the jurors viewed the Moselle property, we all could hear and see that Alex's story was impossible. God gives us all gifts, and the gift of discernment is shared by many. Some of us, either from the courthouse, law enforcement, or jury, at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew, I knew, and they knew, that Alex was guilty. Once we were all back inside our vehicles, heavy-hearted and contemplative, our procession headed back along Highway 63 toward the town center of Walterboro. The wind had died down mysteriously, and the sun began to shine through the clouds. One of the roles of the clerk of court is to be Switzerland between the jury, the lawyers, the public, and any other entities involved. In the moments riding back in our vehicle, and with the jurors and decision-makers in other vehicles, we were just regular people, and our thoughts spilled out. Just as the jury would do in a span of 3 hours, we unanimously came to our own verdict in just 3 minutes. Guilty. In my opinion, the decision to visit Moselle by Murdaugh's defense team did not work in their favor. They were hoping to show that the proximity was too close for one shooter, and they felt like the pictures didn't show the distance correctly, said Doug Brown, who worked for the defense team during the trial. Many of us question if Alex is bipolar, schizophrenic, or a narcissist, while some wonder if he snapped due to financial pressure, Paul's boating accident, and the crumbling of the family dynasty. Right is right and wrong is wrong. When and where did this family begin to blur this fact of life? The moral compass that rules most law-abiding citizens didn't seem to exist in Alex. I don't really want to believe that a father could murder his son and wife. Sometimes, though, the line of love gets blurred and turns into a crime of passion and a crime of desperation. I believe most people cannot fathom killing or hurting a family member, especially in the name of love, but during our time at Moselle, Alex's fate was sealed. Exhibit E is the apology Facebook post. Timothy Stone, February 16th at 8:35 a.m. Folks, I posted a ugly post yesterday, to which I've deleted, and I kinda in a roundabout way directed it towards a certain person. And I would like to apologize to everyone who read it. And then the writing is really terrible. That ugly for me to do that. And yes, I let Satan control me, and I broke down and started drinking, and when I was drunk, I made that post, and I'm sorry. And that brings us to Exhibit F, which is a sworn statement by Mr. Stone, juror number 787's ex-husband. It states, personally appeared before me, Tim Stone, and then the swear-in for a deposition. I am the ex-husband of, redacted name. I did not post anything to the Facebook group Walterboro Word of Mouth between January 23rd, 2023 and March 2nd, 2023. I did not post anything on this social media page or my own Facebook social media page about redacted name being a juror, that redacted name was talking way too much to friends and family about the case, or that Satan had gotten hold of me and that I had been drinking at the time I posted and was now very sorry. Nor did I post what is attached as Exhibit A, which has been represented to me to be an alleged post to the Walterboro Word of Mouth Facebook page and a court exhibit in the state of South Carolina versus Richard Alexander Murdaugh trial. I do not have a Facebook page set up as Timothy Stone. My profile name is Tim Stone, and my Facebook page is redacted. I was never contacted by law enforcement, the South Carolina Attorney General's office, the clerk of court, Becky Hill, or anyone at the Colleton County Clerk of Court's office about Exhibit A, or a post on the Walterboro Word of Mouth Facebook page concerning my ex-wife. I did not know, redacted, was on the Murdaugh jury until I heard her voice on a recording when she was being excused as a juror and she was discussing something about eggs. And the document continues to say, the person who made the apology post is an unrelated person also named Tim Stone, whose Facebook profile picture is not juror number 785's ex-husband. And Exhibit G is from Philip Barber, who after swearing in says, I met an attorney in the firm of Richard Harpootlian and counsel of record for defendant Richard Alexander Murdaugh. On August 18, 2023, I met with Tim Stone at his home. He provided his Facebook login information and allowed me to download a copy of all his Facebook activity from January 23, 2023 and March 2, 2023. A true copy of the download is attached as Exhibit A. The contents of the download speak for themselves, but review of them shows no post was made on February 16, 2023, apologizing for a previous post. There are no posts whatsoever to the Facebook group Walterboro Word of Mouth. Facebook's stated retention policy for deleted posts is 30 days, so any post deleted in this period would not be recoverable. Moving on in the document, on February 28, Ms. Hill questioned juror number 785 about the fictitious post on Walterboro Word of Mouth alone in her office in the courthouse. And this is shown in an affidavit marked Exhibit H. After introducing herself as Juror 785, during the presentation of the defense case, after President's Day but before Mr. Murdaugh testified in his own defense, Colleton County Clerk of Court Rebecca Hill told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdaugh's attorneys. In late February 2023, Ms. Hill questioned me about a Facebook post on the Walterboro Word of Mouth page. She summoned me to speak with her alone in an office in the courthouse. She told me someone emailed her about a post my ex-husband Tim Stone purportedly made, which purportedly stated that I made comments to him about the guilt or innocence of Mr. Murdaugh. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and that I wanted to hear all the evidence before deciding. Miss Hill said the post said I had been drinking with my ex-husband and that while drunk with him, I expressed opinions on the guilt or innocence of Mr. Murdaugh. That never happened, and I told Miss Hill it never happened. I did not go drinking with my ex-husband. In fact, I had not seen him in approximately 10 years. I asked to see the post, but Miss Hill would not or could not show it to me. I have never seen it, and to my knowledge, no one has. Later that day, Miss Hill told me Sled and Colleton County Sheriff's Office personnel went to my ex-husband's house and he purportedly confirmed he made the post. She told me she would reinstate a restraining order I previously had against my ex-husband. I did not know about the apology post referencing Satan until Miss Hill's book was published. I have since reviewed that post and can definitely state the post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. It does not appear to be a post to the Walterboro Word of Mouth Facebook page. When Miss Hill first asked me about the Facebook posting purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she always knew the apology post referencing Satan was not posted by my ex-husband. On March 2nd, 2023, the day of the verdict, I received a call from my ex-husband, Tim Stone, as I was getting on the bus to travel with the rest of the jurors to the courthouse. I did not answer. The phone call upset me greatly, and I asked to speak with the clerk of court, which I did by telephone using bailiff Mr. Bill's phone. I told her I was scared. She said that the Murdaughs probably got to him. Miss Hill then asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Creighton Water's closing was good, but I still had questions. She asked me what kind of questions, and I replied, questions about the guns. She asked what would make me think he's innocent. I stated that no murder weapon was found. She then asked, well, what makes you think he's guilty? I said, Paul's video at the dog kennels. She then stated that everything Mr. Murdaugh has said has been lies and I should forget about the guns. They'll never be seen again. Miss Hill then asked about the views of the rest of the jury. She told me if the foreperson would just go in and ask for a raise in hands, this would be over and done with. She said everyone needs to be on the same page. She then again said she would reinstate a restraining order I previously had against my ex-husband and that she would call Judge Newman about the restraining order. Wow, this is crazy to read that a clerk of court was doing this. It's almost like bribing her to... I feel definitely Alex is guilty, but I really feel that if these statements are true, if she really did this, there is a good chance that the court will have no other choice but to call for a retrial, which is a shame because it's going to cost that part of the country a whole lot of money and a whole lot of time that's so unnecessary. Reading on, I then went to the jury room. Approximately 10 minutes later, I was excused from the jury. During the proceedings, I asked Judge Newman if he had spoken with the clerk of court. He only said, this is not because of your ex-husband. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post he purportedly made because I knew I had not made the comments he claimed I made. He emphatically denied ever making any such Facebook post and genuinely seemed to not know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, Juror 864 and Juror 826 were in the single-toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case. Juror 729 referred to it as A and D time. In the van going to the courthouse, Juror 864 said Special Agent David Owen lied on the stand, but that nothing would happen to him. When we visited the Moselle crime scene, Miss Hill and Juror 826 walked off together, avoiding other jurors in order to have a private conversation. I own a rental property, which is leased to 2 tenants. I'm going to skip their names even though they're not redacted. On Saturday, February 18th, 2023, I delivered a refrigerator to that property. I was removed from the jury on the day of the verdict because a co-worker of I'm not going to say the name, purportedly said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Miss Unnamed then worked at Domino's Pizza in Walterboro, so the co-worker would be some employee of Domino's Pizza in Walterboro. I do not know whether this person actually made any such statement at Domino's Pizza or whether a co-worker actually heard any such statement. After I was dismissed from the jury, I spoke with these 2 people who both vehemently stated to me and my husband that the affidavits the prosecution drafted for their signature was not what they said to him. They told me Sled showed up at their home at 10 p.m. after they were asleep, removed them from their home, put them in separate cars, and questioned them. Mr. said he told them I did not say anything about Mr. Murdaugh's guilt or innocence. Sled returned 30 minutes later, again woke them from their beds to serve subpoenas on them to appear in court the next day. They arrived at the courthouse at 9 a.m. the next day and were held for 9 hours until 6 p.m. when Sled officers or a prosecutor finally presented typed affidavits to them saying they were their statements from the previous night that had been recorded by dash cams in the patrol cars. They said they signed the affidavits without reading them. As I previously testified, I never discussed the merits of the Murdaugh case with these two people or any other person present, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator or during any other interaction with them during the trial. The document continues. Still later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email. And this is found in Exhibit I, which is a draft transcript of records excerpt from an in-camera conference on February 28, 2023. The first page lists all the people who appeared for this conference. It picks up in the middle of the transcript. The court, have you put anything on Facebook? Juror, not regarding the case. I put a positive post on. I gave Miss Becky my full access to my Facebook. I've put positive posts on. I've done that for the past 3 years. But the court, has anyone posted anything on Facebook about you? Juror, I wasn't aware of it until Miss Becky told me today. The court, what did she tell me? Juror, she asked me if I had an ex-husband, and I said yeah, and she asked me if I had talked to him about the case or being on jury duty, and I said no, and I questioned her why she was asking me that. I haven't seen my ex-husband since 2014. The court, does he live in the area? Juror, he does now. He lives in... I'm going to leave that out. The court, okay. Juror, and I have 3 restraining orders against him. Warning. The court, so he's basically up to no good. Juror, I wouldn't say that. I'd say a lot worse. But that's a nice way to put it. The court, okay. Juror, but she told me that. I was very upset after she told me that. Like I said, I have 3 restraining orders against him. I wouldn't have anything to do with them if I didn't have a child with him, but I haven't seen him since 2014 when we got a divorce. I have talked to him within the last year because I got a call at work that my son was in jail and needed a ride home, and I did call his father and ask him to go get him, which he did not do. But other than that, I have not seen him, talked to him, or anything else since 2014 other than getting restraining orders in Colleton County, one in Orangeburg County, and I have one in Berkeley County. The court, wow. Juror, but Miss Becky said she had went to look for the post again and that it had been deleted, and I don't know who she talked to or anything else, but she said apparently, the court, when did she tell you that? Juror, it was after you let us go on that last break. I was very upset, and she came down and talked to me and said that apparently, I don't know who talked to him, but said that he was drunk and he removed the post. The court, so has she discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on that jury? Juror, not that I'm aware of. Court, okay. She was just discussing with juror. She pulled me aside, and when we went downstairs after the last break, I want to say it was after lunch, and we came back. That's when she first told me about it. And then when we went back into court, I was kind of screening the audience to make sure that my ex wasn't out there. And she came downstairs after that break and told me that she had found out that he was drunk and made a drunk post. And I don't know what happened from there. I have no clue. Isn't that just sick? Now this poor woman who's got 3 restraining orders against her husband is sitting there in court, feeling vulnerable, feeling frightened, and afraid that her husband might be there in the courtroom. This is just unnecessary. Back to the exhibit. The court, and you work at? Juror, I work at a monkey farm. The court, monkey farm? What do you do there? Juror, I work in the lab. For the lab. All I do is watch monkeys. It's a testing facility where they try and come up with cures for like AIDS, cancer, leukemia. The court, you're happy to be here away from the monkeys for a while? Juror, yeah, I miss my monkeys. The court, are they pretty smart as everyone says? Juror, they are very intelligent and they hurt and bleed and have feelings just like you or I do. They do. I want to work with monkeys. The court, okay, at this point in time, have you made up your mind as to guilt or innocence though? Juror, I haven't. I was trying to wait on closing arguments because those are usually pretty good. The court, you've been on jury duty before? Juror, I was, but it kind of really sucked because they called us back and we were, anticipating. It was my first jury and they made up an agreement and we never ever got to sit on the jury. The court. Okay. Any questions either for anyone to ask? Mr. Griffin. No, Your Honor. Mr. Waters. No, sir. The court. Okay. If you will stand right inside. Juror. Follow her? The court. Follow her for a second. Gabby, just right outside, inside the other door, but not all the way out. Juror 7-8 exits the room. The court. All right. Comments? Mr. Griffin. Your Honor, I think that satisfies it, and she hasn't talked to anybody, hasn't expressed an opinion, and hasn't made up an opinion, and she's got an ex-husband that she has 3 restraining orders against him. The court. That's understandable. Have a good night. Juror. Thank you. Then we skip ahead 7 pages of the draft. The court says, that's understandable. Have a good night. The juror says, thank you. The court says, okay. Juror, they're going to bring me back to my car, right? The court, they didn't leave you, did they? Juror, yes. The court, oh, they did? Law clerk, no, I'll go get her to the bailiff and they'll go get her. I'll go down there to a bailiff. Juror, they left. Law clerk, and make sure they get her home. Juror, y'all have a good night. The court, okay. Mr. Griffin, bye. Juror 785 exits the room. The court, well, Mr. Waters, I got a name now. The court, a name, and then it says the name. Now at this point, they're speaking about her tenants. But the court, I'm assuming Judge Newman, oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. Mr. Griffin, I was surprised to hear that. The court, yeah. And then this exhibit ends. The document paraphrases what was already outlined in the exhibit, so I'm going to skip down to the bottom paragraph that says juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court, immediately after her excusal, juror number 785 asked Judge Newman if he had spoken with the clerk of the court, referring to the conversation earlier that morning with Miss Hill. Judge Newman responded that I have not spoken with her today and that this is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. Back to the top of page 8 of the document, when the jury began deliberations that evening, Miss Hill told them that this shouldn't take us long, and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, as they had previously been allowed to do during the 6-week trial, but Miss Hill told them they could not smoke until deliberations were complete. There were 6 smokers on the jury, and it cites Exhibit J, which is another affidavit by Holly Miller, the paralegal from Harpootlian's law firm. On August 6, 2023, Jim Griffin and I met with Juror 326. During the meeting, Juror 326 relayed the following information to us. Juror 326 was asked if Miss Hill told the jurors not to let the defense mislead them. He did not specifically recall this statement, but he did recall that Miss Hill commented to him and other jurors about the photos that would be admitted into evidence, indicating that the images would be disturbing. Juror 326 also stated that the jurors were stationed in 2 separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. He was not in the same room as jurors 630, 741, and 785. Juror 326 stated that Miss Hill would visit the other room more often and that he could not hear what she was telling the jurors in the other room. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside of the jurors. He further commented that some of the jurors were going into their office because of financial reasons and that people were talking to coworkers because coworkers wanted information. Before deliberations began, Juror 326 indicated that minor conversation led him to know who was a yes and who was a no. His vote changed with new evidence. As the jury was deliberating, the bailiff and Miss Hill told the jurors that they could not take a smoke break during deliberations. There were 6 smokers on the jury. After the trial concluded, a group chat was formed with the jurors, but Juror 326 dropped off of the group chat because there were too many chats. When asked if he thought the clerk of court, Becky Hill, was inserting himself in the process of the trial, Juror 326 responded, "I can see this." Back to the document. Miss Hill told jurors that after the trial, they would be famous, and predicted that the media would request interviews with them. Miss Hill even handed out reporters' business cards to jurors during the trial. Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. After the verdict and immediately before sentencing, Miss Hill pressured the jury to speak as a group to reporters from a network news show. She traveled with jurors to New York City when they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. So she's gotten to enjoy this for a month. A last point about Miss Hill's efforts to promote her book showed her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colleton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary at the Colleton County Courthouse when it was closed for Confederate Memorial Day on May 10th, 2023. They have Confederate Memorial Day? I never heard of that. The film crew had previously recorded an interview with Miss Hill. On May 9th, Miss Hill sent a memorandum to the film crew purporting to be an addendum to the contract. And that's attached here as Exhibit K. So this is a letter to someone at DreamWorks, aka Texas Crew Productions, LLC. She says, "Dear," and the name's redacted, "I'm looking forward to your upcoming docuseries on the Murdaugh case, and I hope you'll be able to use some of my interview, should you choose to. Because I'm an elected official, we'll need to modify 3 clauses in the location agreement you presented me, as it relates to my authority. Please change the word owner to Colleton County in every reference in the agreement. 3 dates and location fee. Low Country Story, LLC agrees to pay the Colleton County Treasury a fee of $1,000 per day for the use of the Colleton County Courthouse facilities, so as long as it does not supersede any court proceedings. Payment will be made by the close of production. 10. Miscellaneous. Colleton County, South Carolina can only enter into a legal agreement for services if it is to be governed here in South Carolina, not New York. As an elected official, I have no authority outside of the state of South Carolina. Sincerely, Rebecca Hill, Colleton County Clerk of Court." She signs it and includes a handwritten note. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as Clerk of Court for Colleton County and author of the book. Back to the document. The film crew ignored her addendum as the contract had already been executed, but like her jury tampering during the trial, it was an attempt to violate South Carolina Code, which provides no public official, public member, or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself. The beginning of the document said there was going to be exhibits A through L, but I don't see an L either in exhibits or mentioned in the rest of the document, so they must have changed their minds about that. But the next subheading, Legal Standard. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. So that will be the next step, probably, an evidentiary hearing to address these allegations. Next step, if the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. And it cites, in a criminal case, any private communication, contact, or tampering, directly or indirectly, with the jury during a trial about the matter pending before the jury is for obvious reasons deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial, with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. The presumption is even stronger where the contact was made by a court official, where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, and a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Oh, Becky, what have you done? The final subheading argument, a state official, Rebecca Hill, the elected clerk of court, had extensive private communications with members of the jury during trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews, testimony at in-camera proceedings, and other evidence, including Ms. Hill's own book. The court, therefore, must hold a Rimmer evidentiary hearing. If the allegations are proven at the evidentiary hearing, then under binding appellate precedent, the court must grant a new trial unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The subject matter of Ms. Hill's communications was the evidence being presented at trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. The court therefore must grant a new trial if the allegations are proven. In a 6-week trial, people will talk when they should not. They will say things they should not. Mistakes will be made. The participants in a trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of the trial, no verdict would stand, and trials would be repeated forever. To avoid that, courts properly strain to find that mistakes made during trial are harmless, meaning they did not change the results. But the issues now before the court are not the ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury to secure financial gain for herself. Where a state actor engages in private communication with the jury about the merits of the prosecution, the verdict is impossible to sustain. For example, in Parker v. Gladden, a bailiff told a juror in a murder trial, "That wicked fellow, he is guilty." The subject court of Oregon held the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. The U.S. Supreme Court reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. In this case, the court has declared on record that the verdict that jury reached is supported by the evidence, circumstantial evidence, direct evidence. All of the evidence pointed to only one conclusion. That's the conclusion that you all reach now. The court has therefore foreshadowed the outcome of any harmless error analysis. But the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict, even if she coerced the jury to vote guilty at gunpoint, because in the court's opinion, all of the evidence pointed to only one conclusion, the guilt of the accused. A little tasteless to talk about gunpoint when discussing a murder trial, but okay. If the strength of the evidence against the accused in the eyes of the court excuses deliberate jury tampering by a state actor, the result in a directed verdict for the prosecution, a structural error. That cannot be the law. The law requires the subject matter of the communication be harmless, clearly harmless. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. And it goes on citing a couple other examples. Just for the sake of time, I'm going to skim past those to things specific to this actual situation. Telling the jury not to believe the defendant's defense or his testimony when he testifies regards the merits of the case. Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistakes that forced a retrial in Cameron. So skipping down, Ms. Hill had many private conversations with juries about the merits of the case. She asked jurors about their opinions about Mr. Murdaugh's guilt or innocence. She instructed them not to believe evidence presented in Mr. Murdaugh's defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty, and she pressured jurors to reach a guilty verdict quickly so she could profit from it. Each of these actions violated Ms. Hill's oath of office, her responsibility to the citizenry and the judiciary of this state, and Mr. Murdaugh's constitutional right to a fair and impartial jury. The law applied to these facts requires a new trial. The final part, conclusion. For the foregoing reasons, Mr. Murdaugh respectfully submits the court must hold an evidentiary hearing to receive proof of the facts stated above. When those facts are proven, the court must grant a new trial. Respectfully submitted, Richard Harpootlian. So that's it, folks. I don't see a way in which there will not be an evidentiary hearing. I don't see a way in which a new trial would not come out of an evidentiary hearing. Way to go, Becky Hill. I hope your book deal was worth it. Anyway, look forward to hearing the state's response. And of course, I'll share that with you here. I'm also, as I mentioned, working on getting that episode about the new documentary on Fox Nation, The Fall of the House of Murdaugh. A very disheartened Cassidy O'Connell says, stay well and stay tuned.